SRIRAM's IAS, serving the nation since 1985. Ab offline, hoya online, we are the lifeline.
Hello students, welcome to SRIRAM's IAS. Welcome to this concept class number 4. So we are going to bring concept classes, 3 concepts classes in a week, and this will be the 4th concept class. We have already completed 1 week. This is going to be next week. My name is Mayank Bharadwaj. We are going to come up with next concept of polity. This will help you in your upcoming prelims examination on 25th of May 2025. So we have already studied few concepts and now we have moved on to fundamental rights and the concepts within that concept, the bigger concept of fundamental rights. Starting with article number 12, what is state? It is very important to understand the meaning of state because most of the fundamental rights are given against the state. And until and unless you know what the state is, how would you approach court if any of your fundamental rights are curtailed? So when the Constituent Assembly was making the constitution, it was of paramount value to classify, to specify what every authority means. It is very important to understand that what does the state means, what does law means. Because the state can make law which can infringe your fundamental right and then you can move to the court. It's a simple logic, but in order to move to the court you must know what that law is, who makes that law, and if the state is making that law there must be some definition of state. So they came up with article number 12 which defines the state in very simple terms. We are going to see how. Okay. So article number 12, it defines the state into these 4 categories: center, state, local authorities and other authorities. So just see the definition here. In this part simply means part number 3. Part number 3 involves articles starting from article number 12 till article number 35. This part is the fundamental rights of the Constitution of India. Okay. In this part, unless the context otherwise requires, that simply means that if something else is said in some other article, leaving that apart, in this part, the definition of state would be what is written under these quotes. The state includes the government and the Parliament of India. That simply means the center, the union. And the government and the legislature of the states, each state, this simply means the state legislative assembly and legislative councils, and all the local authorities. Now local authorities and other authorities, these 2 authorities have also been written within the territory of India or under the control of the government of India. Now what is this local authority? Now coming here, center simply means the parliament, and the executive, that simply means the council of minister, the prime minister and other kind of ministers, the cabinet ministers and everybody. In the state legislature also you have the state legislative assembly and legislative council if it is there in the state, and then the executive which involves the chief minister, the council of minister of the state and other kind of ministers. Okay. Now we are reading about the definition of state. Each and everything what I am telling here is the part of state. If any of these infringes the fundamental right of the Indian citizen, they can approach court directly under article 32. They can approach the Supreme Court, and under article 226 they can approach the High Court. This is the remedy available against the infringement of the fundamental right by the state, and hence we are reading the definition of state. I hope I am making myself clear here. So state, in the center it is the parliament and the executive. In the states, different state, UP, MP, Delhi, everywhere, it is the state legislative assembly and the legislative council if it is there, and the executive which simply involves the chief minister, council of minister, etc. Here it is the prime minister, council of minister, cabinet, etc. Okay. Local authorities. Now these local authorities have been defined in General Clauses Act. General Clauses Act of 1897 Section 3 and subsection 31, you must remember General Clauses Act of 1897. The word local authorities are mentioned here. Now, simply speaking, what does local authority really means? The panchayats, the municipalities, the district boards, all kind of boards, all kind of local authorities which are there. Okay, that is also considered as state under Article 12 of the Constitution. Now the term other authorities. Now other authorities has not been defined in the Constitution, and that is why confusion has arisen too many times, because every time this concept used to come in front of the Supreme Court, whether a particular organization is covered under other authorities or not. Because if something is not defined in the Constitution or is a little vague, it is the interpretation of the Supreme Court which works. Okay, now we will study how Supreme Court has interpreted this word other authorities. We have already seen this definition. Coming to the next slide, it is important to understand that the definition of state under Article 12 is applicable only on part number 3 and part number 4. Okay. Definition of Article 12 of state under Article 12 is applicable on part 3 and part 4. So other authorities, how different judgments of the Supreme Court has interpreted this word other authorities. Adjusdem generis, this is a legal principle. In one of the judgment, the Madras High Court has propounded this. Madras High Court in 1967, which says that any authority, any organization, any institution which is like-natured to the government, that simply means it is doing the governmental work, the functional work of government, the sovereign work. Okay, the governmental work, the sovereign work, that kind of institution, that kind of organization, that kind of authority which is like-natured will be called as the state, will be covered as under the definition of Article number 12 under the heading of other authorities. The like-natured authorities which is doing the sovereign work, which is doing the governmental work. But this was very vague. There are, the welfare work and the other work has been done by many private authorities as well. Now, in 1967 only, one more judgment, the Electricity Board of Rajasthan judgment came up, and the court has propounded a new, concept that created by state. If any authority is created by the state, it will be called as other authority. For example, under LIC Act, the Life Insurance Corporation was created, Life Insurance Corporation. Under ONGC Act, the body ONGC was formulated or created. It says that any body, does not matter whether that body is a registered society, corporation, or a company created by government, it will be considered as other authority under Article 12. That simply means it will come under the definition of state. So see how court is changing its interpretation. Earlier it says adjusdem generis, then it says created by. So any authority which is created by the state will be considered as state. Any authority which is like-natured of the state will be considered as state. Now it does not matter whether the authority is created by government or not. Here it has to be created by the state, by the government, by some statute. Does not matter whether it is a registered society or a corporation or company. Okay, then came the Y test, the agency and the instrumentality. This has become the basis of declaration of the authority as other authority under Article 12 of the Constitution of India. The Y test is very important. Why that body is created, we have to see whether it is the agency or the instrumentality of the state or not. This word was propounded in 1979 by Justice Bhagwati, one of the most renowned judges of the country. So it was the 1979 case of R.D. Shetty versus Airport Authority of India, and it was said by the Supreme Court that any authority which is substantially financed by the state, substantially financed by the state. The financed of a particular authority, company, corporation, institution is, if it is looked by the state, then it will be considered under other authorities. If it does public importance work, okay, any work authority is doing is of public importance, governmental work, sovereign work of public importance, but government also does this welfare work, public importance work. So if any authority, any company, any corporation, any society is doing public importance work, it will be considered under the definition of state. Third category is pervasive and deep control. If the government have pervasive and deep control over the particular authority, over the particular institution or corporation, then again it will be called as the instrumentality or the agency of government. So in a way, if you see, if authority is financed by the government, it will be called as the agency or instrumentality. If it does some public importance work, it will be called as agency or instrumentality. If the government has pervasive or deep control over it, it will be called as agency or instrumentality. If a government department is transferred to some corporation, okay, that government department, remember this, department of the government is transferred to some corporation, that corporation will be considered as the agency or the instrumentality of the government. And if the government bestows monopoly on some authority, monopoly to do a particular work, that only XYZ company will manufacture drugs of a particular kind, or the chemicals, the import of the chemical is allowed only for the use of ABC company, any company. When that monopoly has been bestowed by the government on some authority, that authority will also be called as the agency or instrumentality of the government. So what we are reading here, coming back to this slide, that finally the interpretation of the Supreme Court was that any body which can be considered as the agency or the instrumentality of the government will be called as state. I hope you have understood. For an agency to become state under the heading of other authorities, the particular authority should be proved as an agency or an instrumentality of the state. And how to prove it? By these 5 factors. I hope you have understood it. Now, important thing is whether NCERT, whether a public, private institution. For example, you have studied in a school. Let's say the name of the school was XYZ private school, and it is affiliated by some university, or let's say it is affiliated by CBSE or NCERT or anything like that. Can it be considered as state? So affiliation does not make a private institution to become a state. If you have studied in some private college, it is affiliated to some university which is a government university, you cannot say that it becomes a state. For that, the control have to be deep and pervasive. Just affiliation is no control or a very less control, okay, to be called as state. I hope you have understood. The case of BCCI came, okay. So to prove any body or any authority to be a state, the Supreme Court judges it with these 5 tests. So BCCI was also given these 5 tests. Is it financed by the state, BCCI? No, it is not. Does it do some public importance work? No, it does not. Does government have deep and pervasive control over BCCI? No. Is it some department which has been transferred to a corporation? No. Has government given any monopoly to BCCI? No. Then why you should call BCCI as a state? Hence BCCI was declared not a state, although it's a registered society. It is a registered society, but it's not state. I hope you have understood this very important information, whether to call some authority as a state, and what should be the basis of calling that authority as state. Why it's important to define state? It's just because the state has too many limitations. The moment an authority is declared as a state, it cannot discriminate the citizens on the basis of religion, race, caste, sex or place of birth. Cannot do that. So there are many limitations if an authority is declared as a state. A private authority which is not a state, can still work on the whims and fancies of the board of director or the owners, but a state cannot. If some authority is declared as a state, it has to take care that it does not infringe or curtail the fundamental rights of the citizen. I hope you are understanding this very important aspect of Indian polity. So this is the Supreme Court photo, and this is the question: is judiciary considered a state? So tell me, central government, the executive, the parliament, state government, the executive, the state legislative assembly, local authorities like panchayats, municipalities, other authorities which are the agency or instrumentality of the government, all these are considered as state under Article 12. What about judiciary? So this question also came up in front of judiciary, and it has interpreted this particular question very beautifully, saying that judiciary, judges, when they are doing the judicial work, when they are adjudicating upon the case, when they are a judge over a case where there is a appellant and there is a respondent, okay, when there are two parties and judge is there, then the judiciary will not be called as state. Judiciary will only be called as state when judiciary is involved in admin work, involved in administrative work, when it is dealing with its own employees or when it is setting its own rules and regulation. At that point in time, judiciary can be called as a state doing administrative work. But when it is adjudicating the case, when it is becoming a judge and delivering justice, it cannot be called as a state. Now why is very important here? Because the state is always limited by the fundamental rights. Always remember this. This is very important. The state is always limited by the fundamental right. The parliament, the executive, the state legislative assemblies, the state executive, the police, the ED, CBI, everybody, the panchayats, the municipalities, the boards, the authorities, nobody can infringe the fundamental rights of the citizen of the country. All these bodies which are considered as state are limited by the fundamental rights. Their power is curtailed by the fundamental rights in the name of liberty of the citizens of the country, okay? But there is no such limitation on judiciary, because when doing justice, it can go beyond fundamental right to uphold justice in the society. That is their job. That is what they do, and that is the reason they have not been considered under the definition of state. It is only considered as state when doing administrative work. So this was our concept class. Thank you very much for joining me, and we will come in the next class with the next concept. Till that time, thank you very much and have a nice day. Jai Hind.